Good morning. So
Morning.
down, I have down a few matters this morning. I'm just going to run through them pretty quickly. I think a couple of you probably appeared earlier this morning than you had originally planned on, so I appreciate that. I'm going to start with just the first position. Like I said, just run through the calendar and get announcements of who's here, how long we think it'll take, whether we have a court reporter. Position one is Ann Timberlake versus Mark Lefkowitz.
Good morning, Your Honor. Lauren Meadows for the defendants.
Good
Okay.
morning, Mario Breedlove for plaintiffs.
Hi, Mr. Breedlove. And I've received the pretrial order, and I've received some motions in limine. Is there anything else that I should have received that I'm not just mentioned?
That's it from our side.
I believe that's all for our side as well, Judge. Thank you.
Oh,
Good
okay,
seeing you.
thank you, sir. And do we have a court reporter?
I did not arrange for one, no, Your Honor.
Okay. Okay. And then I have Rainbow Trust 2 versus Fulton County Board of Assessors.
Good morning, Your Honor. Brad Bowman here for the Board of Assessors.
Hi, Mr. Bowman.
Morning.
I was really hoping to see you and Mr. Thompson maybe announce settlement this morning, but I don't see Mr. Thompson.
I was hoping as much too, Your Honor. We hit a little bit of a snag. Um, I don't see Mr. Thompson either.
Actually, he
Um,
just joined, but we'll give him
okay.
a moment. Thank you, Mr. Bowman. I appreciate that. Um, And then I have DeKalb County versus Jeff Cowan.
Good morning, Your Honor. William Droz with Troutman Pepper on behalf of DeKalb County. Also with my team here, my partner Lindsay Mann and Associate Kadisha West and the City Attorney Matthew Welch.
Okay.
Good morning, Your
And
Honor.
good morning.
This is Chris Held from the Georgia Attorney General's office. On with me is Kathleen McCandless, also from our office, on
Okay.
behalf of Director Cowan and EPD.
Okay, excellent. And this is actually just down for sort of a scheduling order status conference to sort of figure out where we are and what we're doing.
That's correct, Your Honor, and we did not request a reporter, and sorry for interrupting you.
No, that's fine. Okay, thank you very much. I appreciate it. Next position is Marilyn Whitening versus Natalie McCall Gaston et al. This is a confirmation of arbitration or a motion to vacate arbitration. Who do I have here on behalf of the plaintiffs?
Good morning, Your Honor. William Downs here for the petitioners. We do have a court reporter, and I would anticipate, say, 20 to 30 minutes.
Okay, thank you. And who's here on behalf of the defendants?
Good morning, Your Honor. Stephen Becker on behalf of the respondents.
Thank you. And 20 to 30 minutes sound about right to you, Mr. Becker, or?
It really does depend on Mr. Downs' argument, yes.
Okay, thank you. Okay, and then I believe the last matter, which was the Sadiq versus Clovered Inc., is set to appear at 10 a.m. So if anyone's here for that, I think you're an hour early. So let me go ahead and run through a couple that I think are fairly straightforward, hopefully. Mr. Thompson, are you with me? I thought I saw you pop on a moment ago. Nope. Okay, so then let me go to
Your Honor, I do see Mr. Thompson in the participants box here. I obviously he hasn't.
I'm here.
There he is.
Oh, hi, Mr. Thompson. How are you?
I'm doing well. Doing well.
Good. Glad to hear it. So right as you were joining Mr. Thompson, I was telling Mr. Bowman that I had hoped that you would both be here to announce settlement, but that perhaps there was some sort of snag that y'all have hit. What is the status of the case, Mr. Thompson?
I had prepared a settlement order. I received on Tuesday night, Wednesday night, I received a reply from Mr. Bowman, and I think we're not on the same page about what the issues are, as best I can tell.
Okay.
And yesterday, I got the email that evening at 9 o'clock. Yesterday, I took my daughter to Georgia, and
I did too, Mr. Thompson. Go Dogs!
Yes, good dog. Well, anyway, that took after decorating her room. She's put in married housing on the south end of campus, and the dads spent all day fetching stuff, and the wives are helping put it together. But we didn't get back till about 8 o'clock last night.
Yeah, I got back about 9:30, Mr. Thompson. I feel it.
Yeah. We've not had a chance to go over this stuff together, and I just feel like we should be settling the case, but I don't think that the materials that were sent to me were match what the issues are.
Understood, Mr. Thompson. Mr. Bowman, what are your thoughts, sir? Don't tell me you took your daughter to Georgia yesterday too, right?
No, Your Honor, I'm a few years away from that. She's 7, so.
Okay, good to know. What are your thoughts about the progress and the likelihood of progress with some additional time?
Well, Your Honor, I don't know that it's that we don't agree on what the issues are in the case. I think there's just from the client's perspective, there's a difference of opinion about some of the facts about it, but we are continuing to work through it. As Mr. Thompson said, we got the pushback we got from our client on one of the factual issues was pretty recent. And so we are trying to work through that both with them and with Mr. Thompson. I think it is still a resolvable issue, but I know we can't, I also understand that we can't wait and just continue to push the case forever. But I do believe we are closer than we were a couple of days ago, based on some of my conversations that I've had with the client. But I think we, as Mr. Thompson alluded to, I think if we can get everybody to sit down together to discuss and hash out and make sure that just from a factual standpoint, we all are on the same page and have the same understanding, I think we'll be in a much better position to resolve this pretty quickly.
Okay, fair.
I'm hopeful to be able to do that short.
Okay. Well, I have a couple of options if y'all think that it would be helpful. I don't want to let it go too far, because if it's not going to resolve, we need to know it's not going to resolve and then, have a hearing or whatever we need to do. But I do have pretrial conferences next week, and I also have just a sort of regular civil calendar on the 4th of September, that I could try to accommodate you guys any of those days to see if y'all can give you the additional time that you need to sort of work through whatever issues remain and announce more definitively, yes, we are going to resolve, or no, we're going to need to have go through the process. What do you think about that, Mr. Thompson?
That sounds fine. Judge, that sounds fine. I think that Mr. Bowman and I will do well just to sit down and go through these the documents that he sent, and we're going to make some progress on this thing.
Okay.
But
Thank you, Mr. Thompson.
So yes, so additional time would be helpful.
Okay, Mr. Bowman.
I think next week might be a little ambitious for us, but that's not, if you mentioned September 4th, I think that would be perfect.
Okay, then that's what I will do. I'm going to reset this matter for September the 4th. What you can expect on September the 4th is that I'll just say that it is a hearing day, but then what you could expect is that I can't imagine this would be more than a half-day trial. And so if it did not resolve, it's entirely likely that it might, you might expect that the non-jury trial would occur either that afternoon or the next day on the 5th.
Very good.
Okay, Mr. Thompson, any questions?
No, Your Honor.
Okay, thanks so much, both of you. I hope your daughter gets well settled in. I know I'm hoping mine does as well, Mr. Thompson.
Yeah, it was fun.
Yep. Take care.
Bye-bye.
Thank you, Your Honor.
Thank you, Mr. Bowman. Okay. And then I'm going to call on the folks, Mr. Droz and Mr. Held, and your respective teams. Tell me, I mean, this is obviously, I get cases requesting review of administrative judge decisions pretty routinely. This one is obviously a lot more nuanced, and there's a lot more, at least to my mind, that's involved given the issues. But I appreciate that y'all reached out to schedule sort of a status and scheduling to figure out where we are and what needs to happen next. Mr. Droz, what are your thoughts, requests in terms of what the court should be looking at scheduling in terms of a briefing schedule and or a final hearing schedule?
Thank you, Your Honor. And I think you've hit the nail on the head as to sort of what this is about. This is an administrative appeal from a 2-day evidentiary hearing before an Office of State Administrative Hearing administrative law judge. The appeal raises some important questions of statewide significance regarding EPD's implementation of the National Pollution Discharge Elimination System, or NPDES, permitting process. And the administrative record, as we understand it, has not been filed, in part because OSA had submitted a motion to you, Your Honor, asking for permission for leave to file portions of it in an electronic form. So what we had attempted to do in the interim was talk with Mr. Held about trying to set up a briefing schedule once the administrative record was filed, and we had proposed a sort of standard appellate process with a 30-day opening brief, 30-day response brief, and a 15-day reply. We were unable to agree on that schedule, and in the interim, before the administrative record was filed, Mr. Held filed a brief on behalf of EPD. So that sort of, I think, puts us in the posture that we wouldn't necessarily need the 3 briefs, but we do still obviously need a brief. We think it would be most helpful to the court if we filed one that included record sites, And since there's no record yet, we think that that should follow on from whatever the court sets as the administrative record filing date. And if Mr. Held, I'll let him speak for himself, obviously, but since he's already filed his brief, if he needs to update it with record sites, we understand that. But we think that maybe just 2 briefs, and then we had hoped that the court would grant oral argument given the significance of the appeal. So from a scheduling standpoint, I think the things that are on the table are 1, when does the administrative record get filed? 2, what briefs will the court allow? And then 3, will the court allow us oral argument?
Thank you, Mr. Droz. Before I call on Mr. Held, I'll say this. I'm looking at the record. I do see that the motion to file the administrative record via electronic storage was filed in July. I do a couple things. Mr. Freehoff does get notices when things are filed, but as you might imagine, he probably gets hundreds of those filing notices a day. And so generally speaking, if you want us to know that a motion has been filed, the best thing to do is email it to Mr. Freehoff. And I suspect that that's not what happened here. And that I have not seen it before. I was looking at the record last night and today. And so now that I have it, I will be able to connect with the clerk to confirm that they're able to receive the information in that format. And once we resolve that issue, then I should be able to get an order on file pretty quickly. I presume from the motion itself that the administrator of the record is prepared to file it. They just need permission to do so in that form.
I think that's correct, Your Honor, and we're certainly not commenting on the court's diligence, because this motion was filed not by Mr. Held or by me, but by OSA directly, and they may not have actually been aware of the Superior Court rule that requires that the law clerk receive within 24 hours notice of those filings. So sorry the court did not have access to that sooner.
No worries at all. Mr. Held, what are your thoughts, sir?
Thank you, Your Honor. To sort of start where you just left off with the record, EPD has reached out to the OSA General Counsel who filed that motion, and I think they are ready to get it sent up to you as soon as possible. Just for context, and this is in her motion, but it's a fairly large record, but as important as that is a couple of the exhibits for Excel spreadsheets that if they
don't translate well to being reduced to paper.
We look to see what it would look like if you just printed them off, and it's 2,500 pages of numbers that are completely devoid of meaning. So
yes,
that's why you have that motion instead of having a record. I just wanted to give that context. With regard to the scheduling and the briefing and all that, Your Honor, Mr. Droz filed the petition for judicial review on behalf of the county, laying out the county's positions, and so we filed a response to that petition. OCGA 5013-19 doesn't really contemplate a briefing schedule for petitions for judicial review. It doesn't even require a response, but we filed one just to be on record with our position. So I think from our perspective, you've heard from the county, you've heard from us. If the court wants to hear a reply from the county, we certainly wouldn't oppose that. But to Mr. Droz's point about sort of the appellate briefing schedule, if we were in the Court of Appeals, they would file something, we would file something, and then they would file something. And so I feel like we're kind of there short a reply brief. I
disagree with you a little bit, Mr. Held, in the sense that even though the petition that was filed here for review is very detailed and it is not in a truly sort of narrative legal explanation briefing form that I would expect that would assist me in understanding the issues, while yours is, right? Yours is written as a brief motion, legal citation, et cetera. And so I don't want to beat a dead horse, but I do think that it probably will make some sense to have a little bit of a more formal briefing schedule, though not a lengthy one, and also not an opportunity for the petitioners to go back and sort of reinvent the wheel. I mean, they've filed a pleading that has started the process. You have filed a response, and I think what Mr. Droz's point, at least I thought I understood, was instead of the proposal, okay, now the county will simply write a response and then perhaps give the AG's office an opportunity to write a brief reply. So I probably am going to be inclined to do a little bit of that. I just wanted to mention that before you move on with what your additional requests or suggestions, Mr. Held.
That was the only thing I had, Your Honor, except that, we are also on board with an oral argument in this case.
Okay.
A unique nuance for Department of Natural Resources cases that I think the court needs to be aware of. It comes from OCGA 12.2.1. That's 12.2.1 C. For petitions for judicial review from OSA cases in our situation, the case has to be heard within 90 days, which from the filing of the petition, which for this case would be September 4th. The hearing.
Luckily, I have a civil calendar that day.
I caught that earlier, Your Honor. Now, the statute also provides that the hearing can be set within the 90 days and then continued to a date certain outside of that 90-day period. From EPD's perspective, we would oppose that in this situation just because this is an important permit condition that is supposed to be complied with by April of next year. And so I think there's a impetus from our perspective to have the case resolved as soon as possible. But that is another portion of that statute. So as things stand right now, it would be affirmed by operation of law if the case is not heard before September 4th or set and continue to a date certain. And then that provision also provides that the petition must be ruled upon within 30 days of the hearing. So that's something not from the APA. So I just wanted to point that out.
Yeah. And all the more reason from my perspective, Mr. Held, that I get a record and have a chance to absorb some of this material before I have to listen and be able to properly process the arguments that y'all are making. And so, yeah, especially if I'm under a 30-day deadline, given the time-sensitive nature of the issues. Anything else, Mr. Held?
I don't think so, Your Honor.
Okay. Mr. Droz, what are your thoughts, sir?
Just briefly, Your Honor, as Mr. Held noted, that statute does allow for the court to set and then reset the hearing. So you're not constrained by that 90-day period. It is certainly what the statute would hope would happen, but you certainly have the flexibility under that to set a hearing and continue it to the date certain. So, and then the other point I just wanted to make is that since we are the petitioner, we would typically have the last word in terms of a reply brief. And, I raised this issue about the pleadings with Mr. Held going in and said, are you going to file an answer to our petition? And they chose not to do so. They filed a brief. So this is an answer was not required. I don't want to suggest that it was, but their brief it doesn't in any way, shape, or form resemble what an answer or a responsive pleading would look like. And I think the court's exactly right that we believe that it is helpful to the court to have a narrative form brief. And we don't think that there should be a further reply from EPD because they don't have the burden of proof here, that we should have the opportunity to make the last argument to the court.
Well, one of the reasons I mentioned that, and you may very well be right, Mr. Droz, in terms of the petitioner's entitlement to have the last word. But I think part of the issue here is the lack of a record. Now, obviously, Mr. Held was able to create a brief without he has the benefit of that record, but without, detailed record citations or, et cetera. And so that's why I was expecting there would be some additional more detailed briefing. So here's what I'm going to do. Now that I am aware that the record is an issue that needs to be addressed and that OSA stands ready to file it in as soon as I confirm with the clerk that can be accomplished and how best to accomplish it. I suspect that I can get that done. I will be speaking to the clerk today. I'm certain that I can deal with this sometime by next week. Once it is filed in, I think it would make sense for the petitioner to have some time, but given the September 4th issue, I don't know. I think I would like for the briefing to be closer to complete absent a reply in advance of September the 4th. And given that you, without the record, Mr. Droz, have had the benefit of Mr. Held's briefing for 20-something days, I don't think it's unreasonable necessarily to have the petitioner to shorten that window of 30 days to whatever September the 3rd is, which is the day before. I said it's a Wednesday, and it's about 25 days from now. So what I'm going to do is get the record filed in as quickly as possible. If there's a delay, I may have to make adjustments for that. But right now, I think I'm going to have petitioner's initial brief be due by September the 3rd, absent some sort of change in circumstances issue with the record. And then to Mr. Held, thank you very much for educating the court about the scheduling and for the concession that I can set it and then move it. Because I think that's likely what's going to need to happen in order to allow the AG's office an opportunity to here's the thing. I think my standing order says that anybody that wants to file a reply has to ask permission to file a reply anyway, and it doesn't have to be a motion. Just email the court and say, hey, I'd like to file a reply. I also am interested, do the parties expect that they'll need to exceed sort of normal page limits? I mean, I don't really want you to. It's not an invitation for you to submit a 50-page brief, but if you think that's necessary, somebody tell me now so I'm prepared. Mr. Droz?
I think our goal would be to get you something with no more than 30 pages.
Okay. Thank you. So what I'm going to do is make the petitioner's brief due on September the 4th. And excuse me, September the 3rd, I'm sorry. I'm going to issue a notice indicating that this matter will be heard before the court on September the 4th. And then I expect that what I will do is reset that hearing after I get after the record is filed in, is reset that hearing for a later date in September or so my typical motion days are the first week of the month. And I believe the week of October the 9th, the week of October the 6th would be my next motions day, although I might be able to reach it sooner depending on how long the parties thought it would take. I'm assuming it's going to take a few hours to get through this information. At least 2. Mr. Droz, what are your thoughts on oral
I think
argument?
that's fair, Your Honor. I think about an hour and a half to 2 hours is about right.
Mr. Held, you agree?
I do, Your Honor. Yes.
Okay. So what I think is going to happen, the 2 things I know are going to happen is I'm going to notice a hearing for September the 4th, and I'm going to enter something indicating that the petitioner's brief is due by September the 3rd. And then what I expect is I will set a hearing sometime between September the 4th and October the 9th. It will likely be in the afternoon. And so what I'll do is set that hearing for probably 1 in the afternoon, and you guys will have my afternoon. Any thoughts about whether it can be accomplished by Zoom or if there's some reason for us to be in person? Mr. Droz?
I think Zoom would be fine, Your Honor.
Mr. Hill, okay.
I was just going to add, it doesn't sound like we're going to get there, but just to make the court aware, I'm especially set on a case that's going to jury trial in Gwinnett County on October the 14th, and it is likely going to be a 3 to 4 week case. So this would be good to be on the front end of that, but it would be ideal if it was earlier in the week, not the 9th, which is the Friday before trial starts.
Okay, definitely. Mr. Held, what are your thoughts on that?
I think that's all fine, Your Honor. This is not exactly scheduling matter, but related to the record being sent up. You alluded to the fact that we filed our brief without having the record citations or without having the record itself.
Right.
We included a footnote in there. In our citations, we cite to, this motion, that motion, included a footnote that we're happy to update those to the actual record sites when that record does get uploaded. Would you like for us to do that?
Well, and that's really why I was anticipating that there might be the need for some sort of update from the additional briefing, is simply so that all the parties are directing the court with as clearly and directly as possible to the portions of the record that you need me to review specifically. So
I guess my question was, would you like for us to update the already filed brief and just change the citations?
I don't want to create additional work for your
Okay.
team, but I think it would be helpful if it's doable without that much effort.
We'd be happy to do it, Your Honor. We filed that brief knowing that that was a likely possibility.
Okay.
So
Excellent. Thank you very much. Okay. So as I said, that's what I'm going to do. You can anticipate that there will be a notice forthcoming. I'll speak with the clerk today and I will get an order on file. Likely will be Monday, but I'll get an order on file regarding allowing the record to be filed in some form, in whatever form the clerk says can be accomplished. And then the parties will have everything that they need in terms of the record to proceed with briefing. And we will go from there. Anything else, Mr. Droz?
Your Honor, I apologize for this. I was just looking at my calendar for that week of the 6th, and I did note that there's a pretrial conference in that case that's going out on the 14th on the
Okay.
6th. So not that my schedule needs to drive all of this, but I did want to make the court aware of that potential conflict.
Thank you for letting me know that. I will tell you that the week of the 29th of September is sort of a flexible week for me. And so it's very possible that I can get y'all in that week because I typically reserve those odd fifth weeks that you get here and there for random things that I need to fit in, like motions for new trial and such. So I may be able to fit y'all in that week, and that would accomplish both not butting up against your trial and also handling. I mean, these matters are supposed to be handled with reasonable efficiency, and so I don't want to unnecessarily delay them. Even though this is going to be a little bit bigger fish than we're used to some of our OSA appeals. But in any event, so it may be that you're looking at maybe the week of the 29th, which might work better for everybody. Any concerns about that scheduling, Mr. Held, in terms of your availability or other obligations?
no, Your Honor, that week would actually be better for me. I just put together that that week of the October 6th, I'm actually supposed to be in Philadelphia on the 9th and 10th.
Okay, well,
So
that works better
getting
for
away from that
everybody
would be preferable.
Okay, well, then you can look for a likely date setting for the week of the 29th. And again, it will be in the afternoon, though I don't know as I look at my calendar now what date it will be, but we will let y'all know as soon as possible.
Thank you, Your Honor.
Thank
Okay.
you, Your Honor. And on that week, the 2nd and 3rd are ideal. I'm supposed to be out of town on the 29th through the 1st. So
Okay.
wide open on the 2nd and 3rd.
Okay. Thank you both very much. And I will look for your briefing and we'll get the record taken care of as quick as we can.
Thank you for hearing us, Your Honor. May we be excused?
Yes. Hope you all have a good day.
You
You as
too.
well, Your
Go
Honor. Thank
Dogs.
Okay. And let me go back now to Mr. Breedlove and Ms. Meadows in the Timberlake matter. So I've received, so are there any particular specific issues other than the motions in limine, Mr. Breedlove and Ms. Meadows, that y'all wanted to bring to my attention or address with the court for today at the pretrial? Mr. Breedlove?
Nothing in particular, Judge. Our office just got involved in this case less than 2 weeks ago. So frankly, there may be some issues. We're still delving in the file, unfortunately, prior to a potential trial. But nonetheless, that's the situation we're in. We wish we'd gotten the case a little bit earlier. We did file an amended complaint, which I do think would reference would kind of overlap and reference some of the issues brought up in defendant's motions in limine. But I mean, nothing in particular other than the fact that we'll be getting up to speed on certain matters in this case as we're approaching trial. And so we would ask for the court's grace on that. We certainly understand the court's position on our motion to reopen discovery. We got in late, try to reopen discovery to do some discovery that frankly our client's previous attorney should have done. So we'll be getting up to speed as we approach trial. So we'd ask for the court's grace with respect to that.
Thank you, Mr. Breedlove. I appreciate that. On that note, that was really the one issue I wanted to ask the parties about was the issue of the amended complaint. I've not had a chance to review it. And of course, obviously, I am aware that Georgia law says that you can amend your complaint at any time prior to the entry of a pretrial order. I am one of my few colleagues that does not include in my scheduling order a deadline by which to amend the complaint. Because it feels to me wrong to limit the statutory right to amend your complaint prior to the pretrial order. But it does mean that you sometimes run into issues like the one we have now, which is that the court's actually already dispositively ruled on some of the matters that the plaintiffs are now seeking to address. And I think that that is, res judicata or whatever else we want to talk, issue preclusion, collateral estoppel. There's so many ways to look at it, but I believe that's part of what we need to work through. And admittedly, I've not had an opportunity to look at your amended complaint in detail, other than in my review to note that there are either entire causes of action or aspects of the causes of action that you've asserted that I know the court disposed of on partial summary judgment, most specifically anything that would relate to personal injury type damages that would have required an expert to talk about the existence of the potential environmental harm and the resulting proximately caused damages, which we didn't have in this case. And I've dealt with both of Ms. Timberlake's, and they're lovely people. And I'm sorry that it took them so long to retain an attorney. I'm also pleased that they were able to retain an attorney that was willing to jump in as you are, Mr. Breedlove. I do appreciate that. But that's something we're going to have to work through and make sure that we're clear about what will be represented. Now, presented.
And Your Honor, and I would say we in crafting the amended complaint, we obviously did our very best to work around the court's order on the motion for partial summary judgment, or I guess it was a granting partial summary judgment. And so we worked our best to get around that, but we're certainly willing to discuss now we're approaching trial. If there's anything that the court believes claims that we think would tend to be positive in your order on the motion for summary judgment. We did review your order on the motion for summary judgment. My associate attorney and I did before we crafted our amended complaints. I would say that we did our best, Judge.
Thank you, Mr. Breedlove. I appreciate that. Ms. Meadows, what are your thoughts?
Good morning, Your Honor. Yes, the first thing I did when I saw the amended complaint was go to your scheduling order to see if there was a deadline for amending the pleadings, and I saw that there was not. So my initial annoyance, like you, I recognize that under Georgia law, plaintiffs can amend their complaint as a matter of right up until the pretrial order. So that's why we did not file a motion to strike or motion to dismiss or anything like that. I recognize they are legally entitled to. But in the preparation for the motions in limine and the consolidated pretrial order, I really looked at the claims, and to me, the case is a property damages case at this point. The court has already ruled that there are no personal injury claims that can be presented. And so to the extent the purpose of these new claims was to try to add personal injury damages, they can't do that. And I don't think, based upon what Mr. Breedlove is saying, they're trying to do that. So really, from our perspective, they added a whole bunch of causes of action, which is really going to make for a complicated verdict form. But I don't know that it really changes anything. The damages that are available to plaintiffs are still the same. And that was one topic that was presented in the motions in limine. And I'm not going to get into the details of that yet. But, in our discussions with Miss and Miss Timberlake, when they were pro se, there's been a lot of discussions about what they can get in this case. And, I'm not going to go into the settlement discussions that we've made, but we have tried to explain to them this is a property damages case. It is about property damages. It's not about how this made you feel or, you know, anything related to that. It's about what are the property damages and what is reasonable as relates to this. So that was part of the motion in limine, is really what is this trial going to be about? It is going to be about property damages. So I think to the extent that there's all these new claims in here, it's annoying to me as a defense lawyer because now it's new things that I have to perhaps move for a directed verdict on, or it's going to make a complicated verdict form. But in terms of the scope of the damages, the case is really the same case that it's been this whole entire time. So that's why we oppose the motion to reopen discovery. We believe that it's become more complicated, perhaps in terms of legal claims, but it really hasn't moved the case at all in terms of the available damages to plaintiffs.
Okay. Mr. Breedlove, let me say that my comment about your filing the amended complaint, I didn't mean to imply that I thought you were trying to get away from anything or get away with anything. It was mostly just that my initial assessment when I saw it was we're going to have to make sure that these causes of action are reconciled with the structure of, and it sounds as if you were trying to do that at the outset, so that should be an easy task.
And Judge, I appreciate you saying that. I didn't take it that way. But I appreciate you saying that. I would say, I agree with most of what Ms. Meadows said, except for our amended complaint that adds a claim for punitive damages. Under Georgia law, a landlord has an absolute responsibility to make repairs in a residential lease relationship. This wasn't, the evidence was shown in this case, this grossly was not done in this case. And that yields, under Georgia law, punitive damages. And so, although the Timberlakes may be limited in damages to property damage, possibly diminution of value of the property, possibly moving expenses and other things that were not limited, that were not disposed of in your summary judgment order, they can seek punitive damages for failure to repair. If it's intentional gross action on behalf of the landlord, which we believe the operative facts in this case, which haven't changed, notwithstanding our amended complaint, we believe that there's evidence that a jury could consider that and award punitive damages for the landlord's just intentional neglect of the absolute duty to repair the residential lease arrangement.
Understood. So here's what I had an opportunity to review the motions in limine that have been submitted. Given Mr. Breedlove's sort of request for a little bit of grace in terms of their recent addition to the case. Although I applaud you for, Ms. Timberlake will recall, I did say, listen, whoever you talk to, please make sure they're aware that the case is in a very advanced procedural posture. And so I very much appreciate your willingness to jump in and get started, Mr. Breedlove.
Thank you, Judge.
Excuse me. So here's what I would like to do. First of all, this matter, as from the announcement that you received, you would expect that it would be headed for trial the week of August the 25th. And so one question I have is are the defendants ready to proceed to trial on the week of August the 25th?
We are, Your Honor.
And I believe that the pretrial order that was submitted was a 1 to 2 day announcement. Is that correct?
That's correct.
Okay.
Yes, Your Honor.
And Mr. Breedlove, is our plaintiffs ready to proceed to trial the week of August the 25th?
We're ready, Your Honor. This would be any conflicts. This would trump any conflicts we have.
Okay. So I think what I'm likely to do is call this matter in on August the 25th for a jury trial. And hang on one second. Before I commit to that, let me check one thing and make sure I have jurors that day. No, actually I have jurors on August the 26th. So it will be Tuesday. And what I'd like to do, with your permission, which I think will be, I don't want to wait too long, but I also want to give you the benefit of what the rulings are and a better understanding of the what you can expect at trial for purposes of preparation and also the possibility of resolution. And so what I'd like to do, if I could steal an hour of your time on Monday, this coming Monday, the 11th, I'd like for just the two lawyers, of course, the Timberlakes, your clients are free to appear, but that would be the only matter I have set that day. And we could start at, say, 1 o'clock and just plow through, make sure the PTO is final for the court to enter and that we have all agreed and addressed the issues that will be tried after reconciling the motion for the order on partial summary judgment, as well as plow through the motions in limine. And that way, that would give you guys the clearest understanding of what's going to come in, what's not going to come in, what the posture of the case is going to be, again, for purposes of preparing for trial, calling witnesses, or for the possibility of settlement. Is that something, I know it's short notice, is that something that y'all could make work, Mr. Breedlove, for the 11th?
Yeah, we have, surprisingly, we have nothing in the afternoon with the 11th scheduled.
Okay.
That's
Well, I
surprising
had
for me.
something and then the case resolved.
You
So
must be
now I
psychic,
wouldn't have
Judge.
been available either, but now I am. So
You must be psychic, Judge. I'm shocked we don't have anything Monday afternoon already
thank you,
scheduled.
Mr. Breedlove.
1
Ms.
p.m.
Meadows,
is fine.
Okay. What about you?
I was supposed to be interviewing law students for next summer's class, but I will step out for an hour to accommodate the court's request. I'm happy to do
Okay.
that. So
Okay, excellent. Well, I don't want to take you away from the law students because that's important, but
And I'm
but if I could
flexible
borrow
if
you.
if we need to move around the time in the
Yeah.
afternoon, I'm flexible the whole afternoon, Judge. If
Yeah,
Ms.
and I
Meadows
have
needs
the
to move
afternoon
around.
as well. So we can accommodate if that's easier, Miss Meadows.
I think it was supposed to go from 1 to 5. So actually morning
okay.
would be better for me. But if I'm, like I said, I'm happy to.
Yeah, I can't do morning because
because
I've got pretrial motions in a criminal case on Monday morning, so that's not going to work. We would have to be noon or 1, but I promise we'll try to be efficient with your time, Miss Meadows, and get you in and out as quickly as we can.
Appreciate it, Your Honor.
Okay. Last couple of things I'll say, is one, I don't need my scheduling orders in a little bit of a state of flux in terms of jury charges. What it is supposed to say is that I just need your jury charges by the first day of trial, so I have a chance to go through them, because by then we absolutely will know which issues are going to trial, barring some sort of directed verdict type issue. And if you are using pattern charges, just give me a list of the patterns. You don't have to give me the pretty pages that have all the text. Now, obviously, if you're giving me a non-pattern charge, I do need all the text and I do need some citations. Bonus points, certainly citations that say it is good law, but bonus points if it's a citation where it's ever been used as an actual jury charge, all helpful. But obviously, to the extent that these are issues that come up routinely. And so I expect that I'm going to see a pretty well-established universe of potential case law and jury charge. Beyond that, I would encourage you, if you've not tried a case in my courtroom, all you need to do is let Mr. Freehoff know, and he will make it available for you to come in and familiarize yourself with the technology. Currently, we're using Zoom. They're called Zoom rooms. And basically every day that we're trying a case, I will give you a Zoom link. And to the extent that you wish to publish evidence, now you can, of course, still do it the old fashioned way, which is hand pieces of paper to the jury, or, put it up on a big actual mounted board. Those are all still fine. But to the extent that you want to publish, a PDF document, what will typically happen is you'll share your screen and show whatever that document is. We have monitors all around the courtroom and a big board that faces the jury. Only other thing I'll mention, and this is very nitpicky, but if you have anything that is a video that has audio, there is a function inside of Zoom called Share Sound. And you need to know how to use it, because otherwise there will be that awful echo that we're all used to now because of Zoom, and nobody likes to listen to that. So but as I said, in terms of scheduling, in terms of getting through the case and presenting evidence, we're happy to answer questions. Just reach out to Mr. Freehoff. We'll respond as quickly as we can by email. Other than that, what I'll do is plan to see you all on Monday, the 11th at 1 p.m. and we will plow through the motions in limine and make sure that the pretrial order is as final as it can be. And so I will enter it on Monday after our conference. Anything else that you need, Mr. Breedlove, today?
No, Your Honor, I would just ask for the 1 p.m. conference on the 11th. Will it be the same Zoom link, or Mr.
We'll
Freehoff and
send you
someone
a
from
new
Chamber?
Zoom link. Yeah, Mr. Freehoff will send you a calendar invite with a Zoom link.
Thank you, Judge.
Ms. Meadows, anything else?
That was my same question. Thank you, Your Honor.
Okay. Okay, excellent. Well, then I will see you all on Monday at 1 p.m.
Thank you, Your Honor.
Thank you.
Thank you, Judge. We'll be excused.
Yes, have a great day.
Have a good weekend. Thank you.
Thank you, you too.
Thank you.
And for those of you on the whitening matter, if you'll give me about 2 minutes to get a fresh cup of coffee, I will be back with you and we'll get started. Thank you.
Absolutely. Thanks.
Okay. So, Madam Court Reporter, my understanding is you are here on this matter. And so I'm just going to go ahead and call it formally for you so you'll know we're on the record. This is going to be a hearing in the matter of Marilyn Whitening versus Natalie McCall Gaston et al. Case number 25 CV 006293. I'll note for the record that this matter is taking place entirely by video, remotely with all parties' consent. I have Mr. Downs on behalf of the Whitenings, and I have Mr. Becker here on behalf of the defendants. This matter is set down for a motion to confirm an arbitration award and also a motion to vacate an arbitration award. And so with that, I'm going to start, Mr. Downs, by calling on you and sort of asking you to begin and let me know your client's position in terms of the stated error, et cetera, that would necessitate or that the court should be concerned about in terms of the arbitration award.
Absolutely. Good morning, Judge. And I'm also just want to introduce my client, Ms. Whitening, is also on the call as well, doesn't like her videos on, but she is present. And Mr. Whiting may be present as well. Judge, I don't know how familiar you are with this matter. Have you
I've
read
had a
any of the?
chance to briefly review. So I would say I've got a 20,000-foot view of the
Okay.
general issues,
Okay.
but not the specifics.
Okay.
So,
Well, let me share my screen and I'll just kind of
Yes, sir.
walk the court through this. All right. Everybody see my screen?
yes, sir.
Okay. All right. So, I mean, I feel like the 20,000-foot view is all that is necessary really to understand what happened here, because essentially this is an arbitration that, where unbeknownst to the parties, the claims are essentially bifurcated. The liability, like the hearing took place, parties presented evidence, and then parties understood that the matter had been concluded. Post-hearing briefs were submitted, and then after the hearing, the arbitrator entered an interim award, and so it provided for an accounting to occur. But in this, essentially, that wasn't necessarily known to the parties at the time, and so what we're asking for, if I may advance the slide here, is what we've moved under. Obviously, the Georgia law, OCGA 9913, allows the court to vacate or set aside an award where there was a failure to follow procedure under the Georgia Arbitration Act, which this one was. And one of the requirements under the Georgia Arbitration Act is that the parties are entitled to be heard, to present pleadings, documents, testimony, and other matters, and to cross-examine witnesses. And this, has been cited by other case authorities. Essentially, I mean, it's should be conducted much like a trial, where the parties have an opportunity to present evidence on issues and cross-examine witnesses. And that didn't occur here. After the arbitration, an interim award was entered calling for an accounting, and then respondents submitted a litany of post-hearing evidence, and including a forensic accounting report and a spreadsheet of a number of different damages. And the arbitrator would not permit any sort of examination of this evidence, any sort of other submission, didn't reopen anything. And this was not something that was ever discussed with the parties at the hearing. And so based on, we found one case I would, direct the court's attention to, that I feel is, I mean, it's not exactly on all fours, but this Mid-American Elevator case, 189 Georgia App 143. This was an arbitration that got appealed, and the issue that was on the first time up on appeal was there was a discrepancy in some of the numbers that were submitted to the arbitrator. So I think there was like work hours, and so there's a miscalculation. It seemed to be a miscalculation by the arbitrator on the first time on appeal. So the Court of Appeals said there needed to be a rehearing on this issue. And when it went back down to the trial court said, you can do a rehearing, or if based on the record, you can determine the miscalculation, you can, submit a final order within 30 days. So that's what the arbitrator did in that case. Did not have a rehearing, just simply reviewed the prior evidence and entered a final award, and went up the second time. The Court of Appeals said, no, we vacated the award, and that requires a rehearing. And so even though the issue in that case was very narrow, it only seemed to do with miscalculations of numbers. the Court of Appeals still said, no, you have to have a rehearing on this evidence, on this issue. We vacated the award that requires a rehearing based on Georgia law. And that's what we believe is necessary in this case. Just real briefly on the timeline, I may have to kind of bounce back and forth a little bit, Your Honor,
Sure.
if you have a 20,000 foot view to kind of get into some of the specifics. But first of all, I will say that there was no transcript of the underlying proceeding. So Your Honor doesn't have the benefit of reviewing the transcript, but I don't believe that's necessary. At the hearing, I don't think there's any argument that there was no indication at the hearing that there was the trial was going to be bifurcated. There's no indication that we're concluding the evidence for now, and we'll revisit it once additional information comes to light. That wasn't discussed. Only financial documents that were presented during the hearing were petitioners' own tax returns. So petitioners' own tax returns. And by way of a little background, since Your Honor isn't familiar with what this issue was, but is these parties were involved in an LLC, and they could not ultimately agree on how the LLC was to operate, and the LLC was nursing, provided home care. So these individuals, Ms. Whiting and Ms. Gasson, were nurses, and they were in the business of providing care for patients, and they couldn't ultimately agree on how to run that business. And so that was what the underlying case was about. So the records that were presented during the hearing were petitioners' own tax returns. And then the interim award called for an accounting, but there was no guidance as to what accounting, what that meant. So if I could, let me pull up the actual award so we can look at it. But this is what the interim award. This is the interim award by the arbitrator, and essentially the pertinent part is here. This section here that talks about the arbitrator finds in favor of claimants and against respondents jointly and severally, and hereby orders that an accounting occur within 30 days of the date of the order. The business accounting must and shall involve critical financial transactions. Well, to us, this wasn't entirely clear as to what this even meant. The accounting of what? Business account, petitioner's business. Petitioner had started another nursing business herself. Petitioner's business was not a party to this case. So it was entirely unclear what this even meant. And so therefore, we asked for a clarification of the final award. And if I can, let me switch over. Do we see my request for an accounting here?
I do.
Okay. Yeah. So we're asking the arbitrator, what does that even mean? The respondents are ordered to cooperate, but respondents' business is not a party. What does this mean? And the arbitrator issued an order finding it was clear and understandable, denying requests for modification. So, given that, we were kind of left in limbo, and we opted to cooperate with counsel on whatever records counsel wanted, as opposed to arguing about it or going back and forth before the arbitrator. And what was ultimately submitted was this. by opposing counsel. Opposing counsel submitted this as an accounting, which was from a certified public accountant, a letter to the arbitrator stating that they reviewed certain records. Now, what's interesting about this letter is that what it says is that it reviewed the income from community holistic advanced practice nurses. This is also called CHAPA. Community holistic advanced practice nurses was the party's LLC.
The joint LLC.
The joint
that was-
LLC that was a
right.
nominal party to the litigation, right? So that's all this letter says it reviewed. Well, it doesn't say what it reviewed, but it says the only company that's mentioned is Community Holistic Advanced Practice Nurses. It doesn't say what other specific documents. It says we obtained bank statements from who? What bank statements? We compared the annual bank statements to federal income tax returns of Chapin. I mean, yes, we admittedly provided records and tax returns, but that's not clear what the CPA reviewed. And so the CPA then comes up with a figure based on gross bank deposits of $500,000, $544,000. And so not only that was submitted. And I'm sorry, I don't know how to get this yellow line off. So
Don't worry about it. I can ignore it.
Not trying to highlight everything, but in addition to this, Mr. Becker presents a letter, and he's got alternative theories of damages. One of which is simply based on what the accountants came up with, but then he's also got another measure of damages that's based on direct, consequential, and incidental damages. And this included a number of documents that certainly were not discussed during the case and were never admitted into evidence, discussed. Things like lab reports. I'll try to zoom in a little bit. That kind of got rid of everything, but
not the yellow line.
yeah. Yeah, I don't know why it does that. So it did that to me before.
It does it on our courthouse courtroom technology as well.
This is in the record, Judge. This is one of the exhibits that we submitted in the record. But it's just a number of things that are totally unexplained, just by way of letter. And so this was a total shock, and I don't even know what the basis for this was. So we then, after receiving this, objected to it. Submitted an email to the arbitrator and opposing counsel. We have to respectfully object to this. First of all, the accountant's report doesn't even reference my client's business. And then the spreadsheet has a bunch of stuff that's totally unsubstantiated. And so we objected to this. Mr. Becker obviously responded. He did offer to, present testimony if needed. And he offered to present supplemental affidavits. But ultimately, and then it took forever to get a ruling from the arbitrator. So the accounting was presented in December. AAA continues to follow up with us and saying that there's medical issues that the arbitrator is experiencing. And so there's continued delays about this. And then what ultimately, comes down is a final award that just, lists damages. And the damages aren't, I know Mr. Becker wants to say these are the same damages that the accountant put forth. It's just a typo. Well, we don't know that. And a typo is concerning. and moreover, the arbitrator specifically objects or says in this final award, acknowledges that we objected. but overrules it. And doesn't allow us to have any cross-examination on any of the damages. Let me switch back to the
Sure.
spreadsheet. And so, so we don't get any cross-examination on any damages. We don't get to talk to the accountant. We don't get to cross-examine claimants. We don't get to present our testimony of damages to explain the tax returns, explain, our bank statements, how much my clients actually made from this company versus what's reflected on deposits. None of that. And I would contend, I suspect, it's based on the arbitrator's medical condition, that the arbitrator, something happened during the interim, and the arbitrator just simply wasn't paying attention, just didn't, wasn't doing anything further, and just came up with a final award that really had no basis on anything that was discussed.
So
And
in that
correspondence-
context, let me ask you this, Mr. Downs. In that context, what happens if the court were to grant your requested relief to vacate? Does that mean y'all have to start over from scratch, or does that
Yeah.
mean that another arbitrator will pick up what was done, or will you just have to reinvent the wheel?
Yeah, that's a good point, Your Honor. I think we put this in our briefing too. But so as much as we would like to, Your Honor, we're going to concede the issue of liability, right? So the arbitrator heard the evidence and issued an interim award finding that my clients were liable. So what we would contend should happen, Your Honor, is simply a vacating of the final award and ordering a rehearing on damages before a different arbitrator. That's what we contend the remedy is. And I don't think that's, if I were in Mr. Becker's shoes, I would want that, because I believe that would, preserve the issue. I don't believe that this would be, if Your Honor were to confirm the award, I do believe it would get reversed, based on the law. So if I were Mr. Becker, I would want to have a hearing. I mean, we're not going to relitigate all the issues. It's going to be a damage, essentially like a default hearing. And that's the context, Your Honor. This would be akin to, in an unliquidated damages case, that the court were just to enter a ruling based on the pleadings. But that's not the standard. I mean, you have to present evidence of your damages, even if there is liability. And so we're not contending that, we get a do-over, but we do need a hearing to actually litigate and address the issue of damages, so that we can figure out what is an appropriate amount, and not just something that is based on, hearsay, based on whatever. Based on whatever the arbitrator just decided during his illness. So what respondents don't refute, I mean, they don't dispute that they didn't present any evidence of damages or attorney's fees. And that's the other thing, is attorney's fees. The case law is very clear that there has to be evidence of reasonableness of attorney's fees. And here, there was no testimony at the hearing about attorney's fees. It was just a post-hearing submission. And that's certainly, at a minimum, even if Your Honor, Your Honor would have to vacate the award based on that alone. And they don't even address the Mid-American Elevator. They don't even talk about that case in any of their response and distinguish it in any way, because the issue in that case was even so narrow. It wasn't even on the whole amount of damages. It was just based on miscalculations. And a new hearing was required. And they don't even address the request for a different arbitrator, which I think is appropriate in this case, given the significant delay and kind of the discrepancies. And so, kind of getting to some of my final points here on the discrepancies, and I addressed this earlier, the accountant's report doesn't even mention petitioner's documents. It only mentions Chapin, which is the party's joint, their joint company. And so here's why that matters. But we didn't get into any of this because the arbitrator wouldn't allow it. But so in the accountant's letter, it says we determined that income is represented by bank deposits for the period July 1st, 2021 through September 30th, and it comes up with this number. But here for 2022, it concludes that the deposits were 123,000, almost 124,000. The amount of income appears reasonable compared to income reported on tax returns and payment reports. Well, here's the 2022 tax return that we submitted, $54,000. How is that at all reasonable? That's 2.5 times more than what's noted on the tax return. So we didn't get a chance to get into any of this, but that stuff matters. That stuff matters when you're trying to determine damages against a party. You can't just make it up. You can't just allow someone to present post-hearing evidence, with no, it was not evidence because it's not in the record. You can't do that. The amount of the final award, I know Mr. Becker wants to say it's only $3,000 difference, but that's a material difference. That's a discrepancy in the arbitrator's report. Another thing is that the arbitrator in the award, I'm not going to pull this back up, but in the award, you'll see he says respondents are denied an injunction. And so respondents would be us in the underlying arbitration, are denied an injunction. We didn't move for an injunction. It was petitioners who moved for an injunction. Just another example of what I believe is just something was going on behind the scenes on this. And I don't know, but we need a different arbitrator to help us sort it out. And then Patrick Whitening wasn't even at the hearing. He's a named party. The award doesn't mention that there was any testimony or any thing at all related to do with Patrick Whitening. And he's still jointly and severally liable, with Ms. Whitening. And so, I mean, at a minimum, there's so many issues, Judge, that we would have the opportunity to address at a damages hearing. Like, not is Mr. Whitening, we can see his liability, but what are his damages? What are the damages as relates to him? That's an important issue. And so what we're asking for is Judge to vacate the final award and order a rehearing only on the issue of damages before a different arbitrator. And unless Your Honor has any questions, I'm happy to yield to Mr. Becker.
Thank you, Mr. Downs. I'd also like to applaud you for the fact that it's rare that an attorney says, I think it'll need about 20 minutes, and then they actually talk for about 20 minutes. So thank you for that, Mr. Downs. I appreciate it. Mr. Becker?
Thank you, Your Honor. Well, there's a lot here, and there's a lot missing as well. And I'll try to fill in the gaps. First of all, just want to, as a preface, say what Mr. Downs is talking about, the arbitrator's medical condition, it's absolutely pure speculation. There's nothing in the record about this, no evidence at all. This is just, taking a shot and seeing what happens. So that should be completely disregarded. It has nothing to do with anything. We don't know what his situation is.
I don't have a problem disregarding that and focusing instead on the order, and whatever external information might explain the issues that Mr. Downs is pointing to. Let's focus on those issues and whether they are, because it doesn't really matter if they were okay, they were okay. If they were improper, they were improper. And it doesn't matter why. So go ahead, Mr. Becker.
Thank you, Your Honor. So let's start with the interim award and the bifurcating, as Mr. Downs calls it. Well, as part of this is the part he leaves out, one of our claims was an accounting. So we have, there was notice that there was going to be an accounting here if we were successful. So, claiming that this is a shock and a surprise that there would be an accounting is a little bit disingenuous, I think. So obviously the arbitrator wanted to, and I think this actually shows care rather than the opposite, wanted to make sure that he understood what the issues were with respect to damages, and he assessed them properly. So he wasn't going to do all that on nothing because, we had asked for an accounting. We ourselves didn't know what the damages were at that point. So we needed more information, and we were going to present an accounting, and that's what we did. So,
Look,
to,
Mr. Becker, let me interrupt you. I don't. So far, I agree with you 100%. Right? Wasn't improper or inappropriate for the arbitrator to award to order an accounting, and then let's go forward with the accounting. But while I understood Mr. Downs' point about that to sort of be setting the stage more than a specific complaint about an error by the arbitrator, is it's not unreasonable to assume, though, that the evidence generated by the accounting, right, the evidence presented to support the accounting or the actual accounting itself would be evidence that the parties would then be given an opportunity to challenge or to question or to cross-examine.
I understand, Your Honor. Let me address that since you've raised it. So, Mr. Downs made a lot of noise about the fact that there were two, all this evidence that was presented, and I presented a letter that gave the arbitrator an alternative. So, just to back up a little bit, one of our claims was, or a couple of our claims were, a breach of fiduciary duty and unjust enrichment. The law is clear on this, that the remedy for finding liability on these claims is disgorgement of everything. Sure. No profits, no nothing. You don't get to talk about that. It's just whatever you earned, because you should never have earned it to start with, comes back to the party aggrieved. So that was the basis for the first part of my request for damages, which is based on the income of equity advanced. And then the second part of that was, well, if you don't agree with that, then here's a way to analyze the consequential damages, incidental damages, etc. The arbitrator clearly chose the first alternative. He decided based on, and the accountant, his report was based on the petitioner's own evidence, which is their bank statements, their tax returns. This is not something we dreamed up and created. This is something we took and gave to, and I just want to address, I apologize for jumping around, but to address the issue of the Chapin reference, we never gave the arbitrator anything to do with Chapin's records. So he clearly made a mistake in calling it Chapin because he looked at the caption and said, well, this is Chapin. But in reality, it was equity advance. That's what he relied on. And when you go back and take a look at the documents, you see that's exactly what he did. He relied on the documents that we were given by Mr. Downs on behalf of Equity Advanced, on behalf of his client, Ms. Whitening. And he used those documents to come up with the numbers he came up with. And what he came up with was exactly what the accountant came up with, but for $3,000, which is clearly a typographical error. And as I pointed out in my papers, typographical errors happen all the time. And in fact, the case cited by Mr. Downs deals with a mistake, with an error. So it's not uncommon for that to happen. But when you line up the numbers, literally line them up to the penny, except for that $3,000, which was in their favor, by the way, it's exactly what the accountant had specified in his accounting report. So to say, well, now we want to write to cross-examine about our own documents is absurd, because it's a party admission. It's their stuff. What are they going to cross-examine us about in that? It's your documents. You tell us. He certainly had an opportunity, the petitioners certainly had an opportunity to dispute what was in those documents. They didn't take that opportunity. They didn't do that at any point, frankly, until just this minute, which is, again, outside the scope of what they're asking for, because this evidence is extraneous, extrinsic to their motion. And then with respect to having to explain himself about what his reasoning is, he doesn't have to do that. The law is clear about that. The arbitrator just has to give a definite number. And that's exactly what he did. He gave a clear and definite number, albeit he was off by $3,000, but that was the number he gave. And then with respect to fees, we gave evidence of fees. It was there. We showed invoices. We showed a spreadsheet. It was there. So it's not like I dreamed up, this is $43,000 I earned, just out of nowhere.
I think forgive me for interrupting, Mr. Becker, but one of the things I wanted to make sure I understand procedurally, right, to clarify, is even assuming that the accountant's accounting, right, that the accountant's opinion or assessment of the financial impact of let me back up and say this again. So as I understand it, the interim award comes in, there is an accounting that's ordered, and then there is a financial professional who undertakes to conduct an examination of the documents that were already at issue and presented in the arbitration, which are from your position, the financial documents, not of Chapin, but of the petitioners, right? That's correct so far, right?
Yes.
Okay. So where I am a little confused, though, is that the accounting itself and the assessment by the accountant, to my understanding, was not, the petitioners were not given an opportunity to challenge, or excuse me, the Whitenings were not given an opportunity to challenge that opinion, right? Am I correct in procedurally understanding that the opinion that was offered by you with the support based on the assessment by the accountant was done post-hearing, albeit to your way of thinking based on evidence that was included in the hearing? Is that right?
That is correct.
And so one question I have is, let's assume everything you've said is correct and that it's all based on the evidence that was presented during the arbitration. Isn't, though, the accounting and the expert opinion of the accountant who conducted that assessment on which you relied to make representations to the arbitrator, isn't that itself evidence that should potentially petitioners or the Whitenings have been offered an opportunity to challenge?
What specifically would they be looking to challenge? It's their own documents. It's their own information.
Oh, absolutely. Except that we all know that accountants can look at the same information and come up with different opinions, right? And that's really why I'm asking, is that I know it's an accounting, and when it's done in response to a court order, we tend to treat that as sort of an objective assessment, and I'm not implying that it was not. But it also is essentially an expert opinion that's capable of being challenged based on different financial assumptions that parties might make, that sort of thing. That's really what I'm asking is, am I correct procedurally that that person, whoever conducted that, and then the representations that you made to the arbitrator about what was shown by the accounting, that itself was never at issue in the hearing? It was never subject to cross-examination, even though I understand your position that the underlying documents were at issue in the hearing and were subject to cross-examination because they were offered by the petitioner, by the Whitenings themselves.
Theoretically, yes, Your Honor, you're
Okay.
correct. Mhm.
Okay. Go ahead, Mr. Becker. Thank you for that.
Yeah, and then I just had one other point, Your Honor, about Mr. Whitening. Mr. Whitening was a party to the action, the arbitration. If they chose not to put his testimony on, that's their business. But to say that, you know, he's not joint and severally liable because there was nothing about Mr. Whitening, that was a choice that the respondents made, or the petitioners in this case, not to put on Mr. Whitening for any testimony. If that's what they wanted to do, then the testimony we put on would be unchallenged. We talked about all of the respondents in the hearing, all of the Whitenings. The Whitenings were both parties, and it applied to both of them. So the fact that they didn't challenge that, that's on them.
Okay. Thank you, Mr. Becker. I appreciate that. I do have a couple of questions. So generally speaking, the standard for overturning an arbitration award is really, really high. And so I always start from that perspective, and I don't want to overstep in terms of the instructions that courts are typically given to defer absent some specific legal error, et cetera. Let me ask you this, Mr. Becker, in terms of Mr. Downs' presentation, if the court were to say that, express that it believed that the consideration and reliance by the arbitrator on essentially an expert opinion that was never subject to cross-examination constituted a sufficient error, right, that required a vacating of the arbitration judgment, What happens next in terms of what Mr. Downs has asked? What do you think would be the appropriate remedy? Understanding obviously that we might not get there because your clients might appeal and it'll have to go up and deal with those issues. But from a practical perspective, is Mr. Downs correct that he's indicating on the record and in briefing that his client's intention is to, concede liability and move forward only on damages and then request a different arbitrator? What are your thoughts about that proposed resolution, if it's right, wrong, or otherwise?
I don't know what the AAA's process is on, of course, Your Honor, if you direct that another arbitrator be appointed, then that's something we have to follow, obviously. But I don't know that that necessarily would be the case. Even in their own case that they're citing, Mid-America, they went back to the same guy. So why wouldn't it go back to the same guy? Again, saying that this guy had medical issues and, he shouldn't be the same arbitrator, or I didn't like the decision, is not a reason not to use him again. All of that's just pure speculation and opinion on their part. I think we go back to the same arbitrator and we have the cross-examination that he's looking for.
Right. And that's actually why I asked the question, because that is no disrespect, Mr. Downs, but even assuming the court is considering vacating the award and returning it, it does smack of it does give the court concerns about, judge shopping, arbitrator shopping. And I think there's also the added potential for punitive expense associated with starting over, even with a concession of liability. So thank you, Mr. Becker. I appreciate the information. Mr. Downs, I'm going to let you have the last word because it's your motion to vacate. Although technically it's really dueling because Mr. Becker also filed a motion to confirm. So
I'll file first, though, Judge. Yeah, if I may just address a few quick points.
Sure.
Your Honor does have discretion under 9913E to appoint a different arbitrator. And I understand Your Honor's concern about judge shopping, but I don't think it's not going to impose any additional expense on the parties here. It's just essentially a default hearing at this point. We don't have to go back and explain the parties' relationships or anything. It's about the finances. It's about the financial documents. And I just don't think, given the inconsistencies in what's happened, that this arbitrator can be impartial in this instance. I just really have concerns about the ability to be fair. And I just think we'd be back up here before Your Honor, a different judge, if that rehearing before the same arbitrator were to be awarded.
Well, let me say this. If I were to vacate the award, I will say I'm not inclined to order a different arbitrator. If you have concerns about that arbitrator's ability to be fair, then I am confident, although I don't know them off the top of my head, that there are procedures through AAA to challenge, essentially akin to a motion to recuse a judge based on what the party's concerns are in terms of their ability to be fair and impartial, although I also suspect that it would be similar to as a motion to recuse a judge, that just because they got reversed isn't necessarily a reason to remove them. You may have other reasons, but I don't know that evidence is sufficiently in front of me to make a ruling like that if I were to do so.
Okay. Fair enough. Well,
go ahead, Mr. Downs, with
let me
whatever.
address a few other points.
Sure.
I think it's interesting that Mr. Becker admitted that his accountants made a mistake in the report, yet he wants the court to say, well, just rely on the report except for that mistake. We know of one mistake that Mr. Becker's admitting, and we didn't get an opportunity to address any of the other mistakes that are inherent in the report. And that's, I think, what Your Honor's concern is. And I think that that's what needs to happen, is we need to be able to address other potential mistakes and assumptions and error that were made by this accountant. And I think it's also interesting that Mr. Becker points out that the case we cited, also deals with an accounting error. Yes, it does. And in that case, a rehearing was required, for the simple accounting error. And so that's what we need in this case is there obviously is an error on the report. There obviously is an error in the failure to follow procedure. You don't have to get to the, prejudice to the client. It's the failure to follow procedure under the Georgia Arbitration Act entitles the court to vacate and set aside the hearing. And then the other thing,
Due respect, Mr. Downs, I don't think it's as simple as that. A simple procedural error doesn't require reversal. A procedural error that is prejudicial requires a reversal. And so to me, the real issue, right, is whether or not I do think there is a procedural concern here about relying on evidence that has not, essentially, to my way of thinking, is an expert opinion that was not allowed to be challenged, is potentially a procedural error. Whether it was prejudicial, I think, is what is dispositive of the outcome here.
Yeah, it's a due process error. I mean, we didn't get a chance to confront the expert. We didn't get to confront the people making these accusations against us. And then the other thing is that I do want to correct the record to one extent. Your Honor, I think, asked the question to counsel with the assumption that it was the accountant that just reviewed all of the documents that were presented in the case. And that's not accurate. There were documents that were presented post-hearing that were not addressed in the hearing that the expert apparently, according to Mr. Becker, relied upon and based on their own report. If we take that at face value, that they looked at 2023, for instance, and 2024 evidence, that stuff was not in the record at the hearing. So the accountant didn't just look at, things that were cumulative of things that were already addressed at the hearing. There was post-hearing submissions that the accountants would have looked at. And I think that's, even if they had just looked at the hearing stuff, I think we would still be entitled to cross-examine them on that. But certainly for stuff that was post-hearing, that we have an obligation, we have a right to cross-examine them on that. So even figure out what they even reviewed. I mean, it's not clear to me what they even reviewed. And then I just want to briefly address the one other point that Mr. Becker brought up, as far as that it's not as, like, he argued that the remedy for these claims, for the liability in these claims, is disgorgement, and then in turn all of the income generated is the remedy. But that's not what he cites in his briefing. There's no Georgia case he cites that says that. And I think he's not making a distinction between profits and income, right? If we look at just what the profits were for Ms. Whitening from this other business that she started, we looked at the one tax return, that's $50,000 in income. Whereas if you look at the bank deposits or whatever else that the accountants may be looking at, you may come up with a significantly different number. So I think having the ability, a chance to argue the distinction between those two and what is the actual law on that as far as the remedy for these claims is important. And I just don't think we can, based on, the record, before Your Honor, I just don't think it's clear what the arbitrator did.
Well, I think that's a fair point. It gets into way more detail than, thankfully, this court has to address today. But, not for nothing, I think Mr. Becker's point is correct, that even if it sometimes lends to a lack of clarity in an arbitrator's award, the case law is clear that they're not required to give a specific rationale for a ruling. And to Mr. Becker's point as well, even if disgorgement isn't required, it is allowed. And so I don't know that anything about the damage award itself would persuade the court that a vacating of the award is required, simply because it was potentially the maximum that didn't take into account, business operation losses, net versus income versus profit, net versus gross, and it wasn't explained. But I do have concerns, as I said, about the arbitrator relying on evidence that was presented post-hearing and not allowed to be challenged. Anything else, Mr. Downs?
Yeah, I certainly take Your Honor's point about the damage award itself. You don't have a concern about. But what about the fact that we didn't get to brief the calculation of damages? I mean, we didn't get an opportunity to do that, and that's one of the requirements. Is, we weren't aware that the arbitrator was just going to adopt whatever the accountant says, right? We didn't get to brief the issue of what is the appropriate measure of damages, assuming that, this is the the arbitrator is going to rely on this report, what is the appropriate measure of damages? We didn't get a chance to brief that.
Your Honor, can I have
Understood.
a response to that? If
You can, but only because I have a procedural question, and I'm going to let you answer it and then respond.
Thank you, Your
And
Honor.
that is, what were the parties' expectations after the hearing, right? Or at least from your client's perspective, in terms of after you actually had a sort of hearing presentation that was made before the arbitrator, whether on paper or in person. What was your expectation of what was going to occur next, Mr. Becker?
Are we talking about before the interim award was okay? So
Right.
we didn't know, Your Honor. Honestly, we didn't know what the arbitrator was going to do. We did ask for an accounting, and we were clear that we didn't know what the damages were at that point. We needed an accounting. We did believe that if the arbitrator found for liability the way he did, then there would be some kind of accounting that would have to take place, because obviously we don't have the records to do that accounting. That would be in the sole possession of the respondents. So honestly, I don't know. I'm just being candid with the court. I don't know what he was going to do in that situation.
I understand. And then you were going to make a point, Mr. Becker.
Well,
Sorry.
a couple just very quick points I wanted to make. There was a post-hearing brief, which I filed with the papers, and so did Mr. Downs, by the way. So as far as briefing on the damages and what there were, he certainly had an opportunity to do that. I did that in my brief. He certainly could have done that as well. And then the other thing I just wanted to say, Your Honor, is since he's conceded liability, I would ask the court to confirm the award as it concerns liability only. Obviously, if the court finds that there's no reason to not confirm the award with respect to damages, we'd ask that you confirm the award with respect to damages as well.
Thank you, Mr. Becker. Mr. Downs, I was going to ask you that question as well, because as I understand the interim award, right, you have likened this to a sort of default posture in a couple of ways. And it does actually feel that way, whether you characterize it as your client's willing to concede liability, or that at least the interim award indicated that the arbitrator was finding your client's liable in some manner with this issue of damages to be determined later. That does seem to be a fair outcome. What are your thoughts on Mr. Becker's suggestion?
I'm a little unclear as to what you're asking me, Judge. You're asking?
So I understand him to be saying whether it's because you concede or because the interim award essentially was a finding of liability, that essentially the court, if the court's concerned about the damages, the post-hearing matters, right? That the court confirm the arbitrator's finding of liability, at least to that extent, and vacate the post-hearing decisions after the interim award related to damages.
Procedurally, I just don't. My understanding of the law is the court can't really do that. My understanding is what the procedure would need to be is that just simply it's a vacating or not vacating the final award. And so if the court vacates the final award, then what that then in turn leaves is the interim award in place, which we don't have any issue with.
Right, but the interim award is essentially at least an interim finding of liability against your clients, is it not?
I would agree with you, Judge, but
Okay.
I'm not sure what you're suggesting the court should do with that.
I think I just want to be clear that if the court were to vacate the final award, that it's not just a matter of the largesse of your client or the strategic decision of your client to concede liability, but a more clear.
I get it. I get it.
Yeah.
So I guess what the remedy then to me would be to confirm the interim award.
Okay.
Like that's what I think would be. I don't think Your Honor can do anything other than confirm or vacate. So I think
Mr. Becker?
I again, as you said, Your Honor, this is, or Mr. Downs said too, this is kind of like a default situation. And I think it should be approached the same way. We do have a finding of liability. They're not objecting. They're conceding, in fact. So what is the reason to not if you're going to vacate the award based on damages, what is the reason for not confirming the interim award? Since there were essentially two findings here. So that finding, the initial finding, interim finding, was not challenged, and it's not being challenged. So that should be confirmed. If you're going to, and if I recall correctly, the Mid-American case was sent back down just for that issue, to correct that error, not to do the whole case all over again. And we certainly don't want to do the whole case all over again. That would be a very expensive and time-consuming and frankly pointless exercise.
Thank you, Mr. Becker. Mr. Downs, I am actually still going to let you have the last word. If you want to briefly address any of this, let me know.
Yeah, it doesn't sound to me like any of us are in disagreement about this issue. I mean, correct me if I'm wrong, but
no, I mean, I think I've made plain that the concern I have had, is that after the interim award, the damages, even if the accounting was based on documents that were already in the record and that were admitted through the arbitration process and properly before the arbitrator, the actual opinion of the accountant was not subject to cross-examination, was not subject to challenge. And I think that procedural defect, I think, was prejudicial to the Whitenings. Now, as we have gone around, I will say, just to clarify, I don't think that legal arguments about what is the proper measure of damages from a legal perspective are prejudicial, in the sense that there was some briefing. The parties could have said, this is the right way, these are the types of damages, et cetera. What my issue really is that the arbitrator appears to have relied on an opinion of an accountant that the Whitenings were not given an opportunity to challenge. How did you arrive at that opinion? What matters did you look at? What assumptions did you make? And reconcile it, for example, with, what about the tax return that shows this? Where'd you get this number? I don't know the answers to those things, and I don't need to know the answers to those things. I will say I am very hesitant to vacate an award in this manner, because I do think that the courts have been pretty clear in their directives to the trial court that it really requires a significant concern, because we want people to be able to arbitrate and to rely on the outcomes of those arbitrations. But I do have concerns that the inability of the Whitenings to challenge the evidence that was the expert opinion evidence that was presented by the petitioners regarding the damages was a prejudicial error, and that it justifies vacating the final judgment, the final arbitration award. Now, as we have discussed a couple of times, as I understand the interim award, it ordered an accounting based on a finding that there was liability there against the Whitenings. And so, to the extent that I am vacating the final award, I do want to be clear that I believe that the interim award and finding of liability as to the Whitenings should be confirmed, either or both, because no one has challenged it, or because the Whitenings are now willing to concede liability for whatever procedural reasons. I don't think that we're not going to go back and revisit the issue of liability here. Rather, the parties need to potentially revisit the issue of damages. Last two things I will say, and then I'm going to ask Mr. Downs to draft a proposed order for me that's very brief. I need to reinvent the wheel. But two last things I will say. One is, one of the requested forms of relief was that I excuse the arbitrator who was assigned. I am not going to do that. I'm going to decline any request or deny that request. If, as I said, when the parties go back, if there is some particular concern, I am aware, I don't know what those procedures are, but I do know that AAA has procedures for the request to replace an arbitrator. And so the parties can follow that, because I don't think there's, as I said a moment ago, any evidence before the court that would require the arbitrator to be excused. The last thing I will say is on the issue of attorney's fees. I don't know the exact amount of those attorney's fees, and I think they are washed away in the sense that they were part and parcel of the final award. But I will say it does sound to me that the record indicates that the evidence of the attorney's fees was present, and that there was some post-hearing opportunity to argue about reasonableness, et cetera, to the extent that evidence was in the record. So I wouldn't necessarily think that that needed to be reinvented or readdressed. The main issue I'm concerned about is the value of the income or profit that was at issue relative to the whitenings. And so anyway, that's a whole bunch of stuff that I've just said. But the short answer is I'm going to vacate the final award. To the extent possible, I would like to restate in that order that I am confirming or certainly not taking any action relative to the interim award and the finding as to liability, and that I am denying the request to excuse the arbitrator or to replace the arbitrator. Any questions or concerns about what I'm ruling and what I would like to see in an order? Mr. Downs.
No, I think you're very clear, Judge.
Mr. Becker.
Your Honor, I just want to be clear about the attorney's fees. I think you indicated that that would not be subject to your vacate order, but I just wanted to be clear.
I think I share Mr. Downs' concerns that I can't part and parcel it because really I can only vacate or confirm. But the reason I said that, and I wanted to perhaps drop a footnote or something in my order that says, I'm not sure if I'm authorized to confirm a portion of an award, but to express that the award of attorney's fees doesn't seem to suffer from the same procedural defect that the court is concerned about and that has resulted in the vacating of the final award. Does that make sense, Mr. Becker?
Yes, Your Honor. Thank you.
Okay. Anything else?
No, Your Honor.
Okay. Thank you both. Have a good day.
You too.
Thank you, Judge.
Thank you very much.
For those of you who are here for the Sadiq matter, if you'll give me about 5 minutes, we'll get started. It is 10:52, so why don't we just say we'll start right at 11. Thank you. Thank you. Good
morning.
morning. So I apologize that we were delayed so much today. But I appreciate your patience as I worked through those other matters. This matter, Kadir Sadiq, and I apologize if I'm mispronouncing your name, sir. Is that correct?
That's fine. Thank you, Your Honor. That is
Okay.
correct.
Thank you. Versus Clovered Inc. and Universal Property and Casualty. So I was a little confused when I was reviewing the motion for summary judgment, which I understand is it depends on how you characterize it, if it's a partial or a complete, but it clearly seeks to sort of limit, as I understand it, and please correct me when I hand it over to you in a moment, Mr. Fain. It seems to me it clearly seeks to limit a class of claims that Mr. Sadiq might raise and basically say this is a breach of contract, a breach of an insurance contract case, and that's it. But then I was a little confused because when I went back to prepare for the hearing, what I realized was that the discovery deadline actually hasn't run, which might make a ruling on any matter of summary judgment purposes premature. But that not only has the discovery deadline not run, but the parties have actually agreed to extend the deadline for ongoing discovery. Mr. Fain, can you address that a little bit for me, sir?
Yes, Your Honor. The ongoing discovery was just the plaintiff's deposition, which we've already completed. So for all intents and purposes, discovery has been completed on our side, and Mr. Sadiq has not requested any additional discovery as well. So
okay. So the motion to amend discovery or amend the scheduling order that I have pending in front of me, it seeks only to extend that deadline to mediate. Is that right?
correct, Your Honor. We want to get a ruling on the motion for summary judgment prior to to actually mediating the case.
Okay, understood, Mr. Fain. Excuse me. And then the parties were expecting with a mediation deadline in September. Were the parties expecting that it would be on a September calendar, or were you all anticipating that it would be, assuming that it's going, right? That it would be on on a later calendar, say in October?
I believe I was expecting an October calendar, but September would give us enough time. And I think we've agreed on the second week of September to mediate as well. So
right, I think it was September 19th. Right.
Yeah, we're just looking for a mediator.
Okay, thank you, Mr. Fain. Mr. Sadiq, is that accurate to what you understood you had agreed to with Mr. Fain?
Yes, that is very clear. Absolutely in agreement.
Okay, thank you, sir. So then with that caveat, now that I have a better understanding procedurally of where we are, Mr. Fain, if you will take this opportunity to address the motion for summary judgment, and then I will call on Mr. Sadiq to respond. Let me, before you do that, Mr. Fain, just ask Mr. Sadiq. This is a question I always ask people in your position, so please don't think that I'm singling you out. But obviously, Mr. Fain went to law school, and he studied for a long time to be a lawyer. He's been practicing law for some time, and so that often puts people who are not represented by counsel at something of a disadvantage. It is a choice that you make. But I do want to ask you, have you inquired about having counsel? Are you, where are you in that process, if at all?
Yeah, so I'm okay with representing myself. I have legal funds in my family. My grandma actually was one of the clerks for Farragut Marshall. So I have
wow.
several judges and legal minds in my family.
Okay, excellent. I just want to make sure, I like to always address that. Again, you're absolutely free to represent yourself. Just want to make sure that that's something that is addressed. Now with that, Mr. Fain, if you will please go ahead with your presentation, sir.
Yes, Your Honor. So may it please the court, as counsel for defendant Universal Property and Casualty Insurance Company, we have moved for summary judgment based off the plaintiff's complaint fell into claim art. based off the plaintiff's claims failing as a matter of law. Here, there's no genuine issue of material fact, and the policy clearly does not provide coverage for the claim loss, which is a water damage, and that's the loss at issue here. So a brief overview of the material facts in this matter. The Universal provided coverage under a limited perils policy. The effective date at the time of loss was from April 14th of 2023 to April 14th of 2024. It's important to note there that that was just the effective date of the policy that was in place at the time of loss. The plaintiff actually had a policy with Universal since 2017, and that policy was continued to be renewed. But that policy specifically only covered losses for 10 named perils, such as fire, windstorm, theft, but not water in this. But water was not covered under this policy. On or about September 8th of 2023, plaintiff Mr. Sadiq filed a claim with Universal for water damage to his residence at 104 Malone Street Southwest in Fairborn, Georgia. And that was the home that was covered under the policy. The damage was discovered that made it the basis for that claim on September 5th, 2023, when the plaintiff returned from a trip out of town to Augusta, Georgia with his family. Upon return to his residence, he saw the water damage and he turned off the main water valve to the house and attempted to identify the source of the leak. Plaintiff discovered that a pipe had connected to the water heater had bursted, and that water heater was actually located in his attic and had caused water damage throughout his house. After the claim was initiated, Universal assigned Edward Kelly, an adjuster with Alder Adjusting, to investigate the claim. He inspected the property on September 12th of 2023 with the plaintiff present at the time of inspection. Plaintiff informed Mr. Kelly of the water damage and possibly that the water had been running for 3 or 4 days. Both the plaintiff and Mr. Kelly during the inspection confirmed the source of the water damage being the burst or the pipe that busted to the water heater, and also that the damages to the property being water related. And this was also confirmed by the plaintiff's testimony at his deposition. As mentioned, water damage does not fall within the policy's 10 named perils insured against. Therefore, Universal, after inspecting the property and also reviewing the policy terms, denied the claim. Following the denial of the claim, the plaintiff filed a lawsuit. And after the lawsuit was filed, that's when the plaintiff issued a demand letter, which is dated for September 27th of 2024. Again, that demand letter came after the lawsuit. Under OCGA section 9-11-56, summary judgment is appropriate when there's no legal issue of material fact and the moving party is entitled to judgment as a matter of law. The plaintiff in his complaint, he's alleged negligence and seeks tort damages. And Georgia law is very clear on that, Your Honor, that Georgia law bars tort damages arising from a breach of contract. Under Leonard versus Fireman's Insurance Company and also Tate versus Aetna, insureds of a policy cannot recover tort damages based off the insured's alleged failure to pay a claim. The only extra contractual remedy is for attorney's fees and penalties of 50% of damages, and that's under OCGA section 33-4-6. But that was not pled in the plaintiff's complaint. And even if his complaint could be construed to allege a bad faith claim under OCGA 33-4-6, there was no pre-suit demand at least 60 days prior to the filing, which is a prerequisite of that. There's also been no evidence of any bad faith presented regarding Universal's bad faith, and non-payment alone is not evidence of bad faith. Here, Universal investigated the claim, investigated the reason of loss, and made a reasonable coverage determination. The only actual and basically these is Universal's position that the complaint's been dressed up as a tort claim, or a tort lawsuit, but the actual underlying claim is a breach of contract claim, which we laid out in our motion for summary judgment. And there he can't prevail either against Universal. Again, the policy provides coverage for only 10 named perils. and water damage is not one of them. And the plaintiff admitted on multiple occasions to the adjuster and during his deposition that the loss was a result of water due to a pipe bursting to his water heater. Under collaborative.
Mr. Fang, sorry, let
Yes.
me ask you a couple of questions. So, separate and apart from the damages issue and the nature of claims that an insured can make, right? Let's talk. I have a couple of questions about whether or not there are disputed facts here, right? Because Mr. Sadiq's main argument, as I understand it, is that the house was misclassified in the policy. Now, that may have been for a long period of time, such that, you know, he might have been legally charged with knowledge of it. But what of issues associated with that in terms of his claim of a failure to timely investigate it, and also his claim that that the agent, and I don't know if these are captive agents or independent brokers, but that the agent sold him something different than what he requested and misclassified or mischaracterized his property for purposes of providing coverage.
Yes, Your Honor. So, and the issue was taking place as, again, this is a limited peril policy. The plaintiff is taking issue with coverage being issued under HO8 or HO8 policy. Instead, that he's alleging that he intended an HO3 policy. In Georgia, courts have repeatedly held that insureds are presumed to know the contents of their policy, and they have a duty to read that policy as well. As mentioned, he had this policy in effect since 2017, and if he intended for that policy to be that or to cover water, it was his duty to read the policy and also inform Universal of the mistake. But the misclassification, the wrong year, if anything, that's a unilateral mistake, Your Honor, and not a mutual mistake. So it wouldn't give rise to reforming the contract that was agreed upon them, or agreed upon Universal and the plaintiff, and also the premiums and everything set as far as what damages would be covered under that policy.
Understood. Thank you for answering my question, Mr. Fang. Please go ahead.
Of course. So let's see. And actually, I was just getting there as far as the language in the policy. The language, the contract terms here are very clear. They're unambiguous, and they must be enforced as written. Courts do not have the authority to rewrite insurance contracts to create coverage where none exists. So again, here he was. And admitted during his deposition that he received the paperwork from Universal over the course of since 2017, and continued to renew and pay the premiums as to the contract that was set out. Again, limiting the perils to the 10 that were in the insurance policy, but but that didn't include water damage. So as far as the tort claims, it's the Universal position that they're not legally viable under Georgia law. Again, it would be a breach of contract claim or the only statutory remedy, which is the bad faith claim. But again, it doesn't meet the bad faith standard. And also the policy clearly doesn't provide coverage for the water loss. Universal position that no genuine issues of material fact exist, and therefore we respectfully ask the court to grant judgment in full favor of Universal.
Okay. Thank you, Mr. Fang. Mr. Sadiq, your response, sir?
Yeah, so if I have on Exhibit C submitted to the court, clearly shows, it's called an inspection acknowledgement report from Universal Property Casualty Insurance. And in that inspection acknowledgement, it states that they would do an inspection and physically take photos of the house and document the square footage, et cetera, et cetera. It's noted as Exhibit C. Also, I have submitted Exhibit B as well, which shows that the house was noted in 1985, which to me is a gross error on their part with the initial policy that they actually submitted to me. They have not made any changes to the initial policy. So their underwriting, who are supposed to be professionals and experts and do it every day, aren't supposed to make these fundamental errors in issuing a policy that's classified for an historical home as opposed to a brand new home that was erected in 2016. That's just too gross of an error. In terms of us actually looking at it and reading the policy, again, we read through, and at that time, even my wife was reading any mail that comes to the house, because I'm just, inundated with, 9 children, 3 different businesses, traveling back and forth to the country. Honest with you, I don't read all of the mail like that, but she does go through it. And her limited knowledge and information, I guess understanding of the information may be limited, but actually good faith is what we were really dependent on. Good faith by the underwriters to give us a policy that was accurate and fits the year of the home that was actually erected. So when it started out wrong, it remained to be consistently wrong every time they sent that wrong policy for us to acknowledge. So that's my, reasoning in arguing that, this summary judgment here should not be awarded. And even those, the facts of this thing can really be, I think, better determined in terms of a jury trial. And I'm pretty sure I have other evidence as well that it'd be convincingly for me to be victorious in that trial.
Okay. Thank you, Mr. Sadiq. Anything else that you want to present, sir?
No, ma'am. Thank you.
Oh, okay. Thank you. Mr. Fain, it's your motion, so you get to have the last word.
Yes, Your Honor, and very brief. It just goes back to the duty to read the policy for insureds. If an insured fails to read the policy, they generally cannot claim later that ignorance or claim ignorance of the policy terms to avoid application or enforcement of the policy. It was on the plaintiff to read and understand the policy, and also he knew that his house wasn't built in that year and could have easily corrected that if he intended to have a different type of coverage on his property, Your Honor.
Okay. Thank you, Mr. Fain. So I have had the opportunity, I've had the benefit of your argument. I've also had the opportunity to review the complaint and to review the summary judgment motion, as well as Mr. Sadiq's response. And one of the reasons, Mr. Fain, that I directed you to sort of address that larger issue of whether there's a factual dispute regarding the whether there was bad faith, denial, et cetera, right? Whether there was some issue, factual issues that might require a jury, is that I agree with you as an initial matter that the first basis for your summary judgment motion, right, is the law is exceptionally clear, as clear as many things are in the law, that the nature and type of damages that can be recovered for a breach of contract are breach of contract damages and not tort damages. And so to the extent that the complaint seeks to recover things that are non-economic, non-directly related to the contract breach. In other words, things that are not covered by the contract, right? When a contract is breached, the nature of the remedy would be the things that should have been covered by the contract, particularly in the insurance context. And beyond that, there is not, the law does not allow recovery for extra contractual damages in this context, absent some proceeding specifically under that bad faith statute, which I don't think is necessarily satisfied here or correctly or directly pled, I should say. So the real issue for me then becomes whether or not there are factual issues that would require a jury to resolve them. And Mr. Sadiq, while I do sympathize with the very awful position in which you found yourself when you came home and discovered this damage, and then later reached out to the insurance company only to be told that there was no coverage, it does appear to me that the fact of the coverage was known to all the parties, and that to the extent that you have pointed to matters that might create a fact issue, they are, I think they don't succeed in accomplishing that for 2 reasons. Number one, I had already noted that the Exhibit C, I think you pointed out, that you sent to me, pointing out that they said they were going to do an inspection, but that was in 2017. And so to the extent that your argument is that they didn't inspect it or that they improperly inspected it, et cetera, it was so long ago that it wouldn't necessarily be actionable or, something that the court would change the outcome here. In addition to that, and really the main issue, as Mr. Fain correctly points out, is that the law is also pretty clear that insureds are required they are charged with knowledge of what's in their policy. And that's why insurance companies send us the copy of our policy every year and say, this is what's covered. This is what's on your declarations page. This is what we will cover and what we won't cover. And I think that the defendants have successfully demonstrated that this was a specified hazards policy and that water damage was not one of those specified hazards, and that there would not be coverage here. And I have not seen anything in the record that would indicate that the mischaracterization, one, even if it were actionable, would change the outcome here in terms of creating coverage that wasn't purchased or wasn't there. And so for that reason, what I'm going to do is I'm going to grant summary judgment to the defendants in this case. Mr. Fain, if you could please provide me with a proposed order, very brief, that just sort of generally outlines what I've said, just to give me something to work with. Mr. Sadiq, what will happen is Mr. Fain will send me a Word version. Actually, he'll send it to Mr. Freehoff. That is just a general outline of a document that I can then edit and review. He'll copy you on that so that it's not ex parte, so you'll see what he's proposing. If you have concerns about it, you can let me know, but I do want to be clear that when I say if you have concerns about it, what I mean is if you don't believe that what he submits accurately reflects what I've said here today, then you can say, I don't think that the judge said that, or I don't think the judge ruled that. That's perfectly fair. Then once I get that and make sure that no one has a concern or that they've had an opportunity to communicate to me a concern, I will finalize that order to my satisfaction and file it. And then once it's filed, you all can take whatever steps you wish to take in terms of if you wish to pursue an appeal or whatever else might occur from there. Mr. Sadiq, do you have questions, concerns, or anything else that you want to address regarding the ruling that I've just indicated?
No, how long would it take you to do your final order?
It shouldn't take too long. It's mostly I'm going to probably give Mr. Fain realistically maybe a week to submit a proposed order. So today is Friday. If I could have it by next Friday, I suspect that I would be able to get it on file for you the week after that, which I think is the week of the 17th, 18th, something like that.
Okay, thank you.
And then, as I said, I'll finalize it. And once it's final, you can take whatever action you would like to take. Any questions for me, Mr. Fain, regarding my ruling?
That's it, Your Honor.
Okay. Thank you both for your patience this morning and your understanding, and I will look for that proposed order and get it on file. Thank you both.
Thank you, Your Honor. Have a great week.